design patents can be a powerful tool to enforce your intellectual property rights if you're an e-commerce seller. And today we're going to talk about design patents and design patents infringement. So my name is Derek Fahey. I'm an IP and patent attorney with the Plus IP firm, and we work with e-commerce brands quite often. And I get a lot of questions about design patents and design patent infringement. And I think it's a great tool if you're actually trying to lock out some of your competition to create a barrier to entry for others. So first off, let's talk about what design patent infringement protect. Design patents protect. Design patents protect the ornamental features of something, what something looks like, okay? Unlike utility patents, which protect the functional features of things, design patents actually only protect the ornamental features of what something looks like. So in the case of a cool looking lamp or a interesting cell phone case or a chair, these are the kind of things that look cool that can be protected with design patents. And design patents typically are easier to actually acquire than utility patents. And the reason why is the legal differences between the two, but also because you actually, with the design patents, you actually focus on what something looks like. And just quite frankly, it's easier. To get a design patent, you actually need to have some new design that's ornamental, that's not obvious in what's currently existing. Like I said, they're typically easier to get than utility patents. So let's actually look at a design patent. I actually have one here. Here's actually the first page of a design patent. And this is actually for cell phone case. And what's covered here is you can actually see there's a cell phone case and there's a strap here. So design patents protect only what's covered in design patent, or the stuff that's not hashed, or if you look closely here, this is not hashed, but the strap is, okay? So this design patent does not protect the strap, what the strap looks like, but it protects the shape of the case. In particular, see this little thing here where that ring goes into? That's the position of that ring. So that's what that design patent protects, what it looks like. Now, in order for a device to be infringing, or an accused device to be infringing on a design patent, you actually look at the ordinary observer test. And the ordinary observer test says that if you look at the claim design that's in the design patent versus the accused device, in light of the prior art, the ordinary observer will be drawn to the differences between the two. And if the designs can be confused more or less, then there's infringement. Now, that sounds complicated, right? Well, it kind of is. Legally speaking, design patent infringement can be a difficult test to decide, and it's decided by a jury, typically. And that test, having a jury which may consist of non-technical people applying a technical test over specific elements, can be complicated. And that can be a very difficult thing to understand whether or not it's infringing or not. So many times businesses will make the decision to not mess with design patents if we think there's a design patent infringement. Why? One, many times juries will actually give a lot of credibility to the fact that a design patent was issued. So they may say, well, this person has a design patent. They may not really understand the design patent infringement test. And the jury may actually, just decide, give more credibility to the design patent that it should actually get. Whether that's good or not, I can't really say. It depends on your situation, but that's just a matter of fact, okay? These are complicated tests that are applied by not technical people. So that's the first thing. The second thing is that because it's so complicated and because there's so much indecision, businesses like clarity. And many times businesses don't want to actually fight it if it's not worth it. So you may have somebody that is considering coming into the market, may see another design patent and say, you know what, I don't want to spend the money on litigating this, so I'm just actually not going to actually produce a product and deal with the design patent infringement. On the other hand, companies may say, I don't care. I'm okay with the risk. My risk propensity profile is higher, and I'm okay with doing that. But long story short, design patents can be easier to get than utility patents. They may, even though they're more difficult to enforce, they actually are difficult to decide whether you're infringing or not. And businesses don't like uncertainty, so many competitors that are, good reputable competitors may not actually want to actually come into the market because of that. Then lastly, e-commerce platforms may actually have systems or do have systems to decide design patent infringement, and they may actually take down the infringing products if you file complaints. You just got to be careful though, because if you do so without a reasonable basis, you may actually walk yourself into a lawsuit that you don't want to be in. So design patent infringement can be a useful tool for enforcing, but just be careful knowing that if you enforce your patents without a reasonable basis to do so, you may cause a lot of problems for yourself. So I hope you enjoy watching this video about design patents and design patents infringement. Thanks so much for watching. If you like this video, please hit that like and subscribe button. It really helps my family and my business, and you can get more content that you also like. Thanks for watching.